of a startup not working out, or maybe one of the founders deciding that they don't want to be involved with a startup anymore and walking away from the project. And basically, the issue is not having vesting in place for the founder's shares. So the way vesting works, I think most of your listeners know this, but it ensures that when you get shares in a company, you don't get all the shares up front. You have to stay with the company for a certain amount of years to get all your shares to include. So what happens if you don't have any vesting in place when you set up a company is, say you have 3 founders and they've been working on a project for 6 months, and 6 months in, one of them just leaves, says, I want to get a job, I can't do this anymore, I'm not going to be involved. By default, they still own 1/3 of a company at that point. And if the other 2 founders want to keep, advancing the project and keep working on the company, the 3rd founder is still going to continue getting 1/3 of the benefit of that, even though we're not involved in the company, which can be a bit unfair and can result in disputes. So what vesting does is that if that founder leaves based on when they leave, they'd have to give a portion of their shares back. Like, they'd keep some to account for the work they already did for the company, but they wouldn't keep, in that example, all 1/3 of the shares, because again, they're walking away and they're no longer involved. So
hello and welcome to another episode of Promethean Leader. Today we have a very special guest, Marius, a partner at Segev law firm, which is located in downtown Vancouver. Marius specializes in startups, technology, gaming, and esports law in Canada. Marius has helped numerous startups navigate complex legal landscape, and today he's here to share his insights on common legal issues startups and new founder faces, and provide practical advice on how to avoid and resolve these challenges. Marius, thank you so much for joining us today.
no problem. Happy to be here.
So I just want to start off with a little bit of background to get to know you and what made you interested in working in startups and technology.
Yeah, I've always been interested in startups and technology. Coming out of law school, like I didn't want to do insurance law for the rest of my life. I didn't want to do litigation. I wanted to do something in business, and startups and business are kind of sort of the most vibrant area of the business field. Like, there's always people coming up with new ideas. There's always cool stuff going on. This is really kind of the engine that drives the economy. Like, new people come up with new things, new business structures, not kind of rehashing old existing structures. So it's cool to be part of that and work with that in some capacity.
Yeah, for sure. Like Vancouver is becoming kind of like a hub for startups, and I have seen a lot of growth in startups in Canada, especially in Vancouver.
Yeah, I'd say like the scene is, especially in the last like 5 years or so, has definitely grown. I think right before COVID, we had something like 12 unicorns in 1 year or something like that, which is pretty good. There's definitely a lot more community engagement, I find, in the last few years. It's less siloed. There's more events, people getting to know each other, starting stuff. And we've had like world-class companies come out of here, like recently Dapper Labs, GeoComply, all sorts of things. You can build a world-class company here, no problem.
Yeah, for sure. Like as you said, a lot of community events are happening too. Like I believe a new one is coming out, which is Vancouver Startup Week, starting from 31st May. I'm not sure when the recording will be out. It's already done, or maybe like it's happening at that moment. But yeah, so I'm also seeing a lot of events happening related to startups.
Yeah, it's definitely grown. It's great to see. Like it's always, I think this stuff like does a lot for the economy and like really helps. There's also a lot of like, our profile, I think, is increasing in North America as a startup hub. So I think it's great to see.
Yeah, well, I did put out a call to get a few questions from founders and startups who are maybe thinking about starting a new company or getting into the entrepreneurship, to send in their questions and what kind of problems they think they will be facing or what kind of questions they have in mind, just generally. So I did receive a few things. So I just want to ask few of those questions and see how that goes.
Yeah, absolutely.
So to start off with, the very common one, that I received was regarding what type of business structure should you register in Canada, sole ownership, partnership, and like how to form a company.
So in Canada, it's nice and simple. It's not like the US where you have LLCs, C corps, S corps, all that stuff. In Canada, it's pretty straightforward. You just have a company. You can have a provincial company, like a company registered in BC or Ontario or another province, or a federal company, but that's really your only choice. There's not really different types of companies. It's just a standard corporation. There's a few unusual sort of pass-through entities and stuff like that you can set up for tax purposes, but for 99% of companies, it'll just be a standard, straightforward.
So what's the difference between having it registered in, let's say, BC or having it registered as a federal company?
There's not much difference. A lot of people think that like a federal company has like more prestige or something like that because it's registered federally, but it doesn't really get viewed that differently. Fine. The corporate legislation is similar in BC and in all the provinces and federally. Everything will work more or less the same. There's a few nuances here and there. So, for example, federal companies have the director residency requirements. So at least 25% of your directors have to be Canadian residents. BC companies and Ontario companies recently don't have that anymore. It's also the issue of, will you have to deal with a BC corporate registry or a federal registry if you're maintaining your own company to do the annual reports and all that stuff. But really, there's not much difference. I prefer BC companies just because I find the BC corporate legislation is simpler and the BC corporate registry is kind of easier to deal with, but it doesn't make too much difference if you register federally or BC.
So are there any advantages such as, like, let's say if I registered in BC, will I get more of like government incentives, grants related to province?
Not really. There might be a few BC specific programs that require you to be registered in BC. I'm actually not aware of any of them off the top of my head. Generally speaking,
yeah.
Sorry, go ahead.
So like, what about like any kind of, so you said like it's fairly similar. So are there any disadvantages? Like, for example, if I registered in BC and not federally, would I get into like, let's say like, oh, you can't do business in that province because of this or that or anything like that?
No, not really. So if you register federally, you get your name is protected Canada-wide, so you keep your corporate name Canada-wide. That is an advantage, but it doesn't make that much difference because your corporate name is not your trademark and it doesn't give you right to sell products under that name. A lot of people get confused on that, so it's not a huge issue.
I see.
And you can do business as any province, whether you're registered in BC or federally. What you might have to do is extra provincially register in a different province if you're registered in BC. Like if you have a BC company and you open up an office in Ontario and like you actually have staff there and a lease, you have to actually register with a corporate registry. So you have like an address for service there. But that's pretty quick and straightforward. It's like a couple $100. You can have a law firm hold your books and it's not a big hassle.
So in terms of corporate names, so if I just registered in BC and it's not federally, so can someone maybe in Ontario, for example, register same company name and start doing business?
Yeah, they can register the same company name, but just be aware, but them having that same company name doesn't give them the right to do business under that name in terms of like selling products under that name. So that's, a lot of people get confused by this because I think if you want to call your company like Acme Contracting, something like that, I think if you register a corporate name, then nobody else can use that name to sell products under Acme Contracting. That's not the case. To protect your name, you need a trademark, and that's completely separate from your corporate name. So you can call your company whatever you want. What matters is that you have a trademark over whatever name you want to use, and you get that by using the name in the marketplace, like having a website, having a storefront that sells names under that product, and potentially registering that trademark. But you have to do that anyway. So it doesn't matter what your corporate name is, and registering that corporate name will not protect your trademark. You have to do that separately.
Okay, so register a business and then also register the trademark. That's very important for first time founders to understand that it's a separate thing.
It's a separate thing, yeah. And a trademark, you don't necessarily have to register it. So if you put out a website and start doing business under that name, you already have some rights to that name already automatically. You don't have to like file anything anywhere. And in theory, if somebody else starts using that name in kind of the same geographical area as you can, say we have a name, send them a cease and desist, and all that stuff. You should register because that makes it easier. That just confirms that you have that name and you own it. There's no longer any dispute about, hey, we started using it first and all that stuff. But it's not automatic. You don't have to do that the moment you incorporate. I usually tell startups if you're like on a budget and cash is tight, you can wait until 6 months, a year down the line to file that. And the trademark application also takes usually a year or two to kind of pass through. So it's not an instant.
But that's how long a process is to start a process on trademarking your identity listed.
Around a year to get an application in, but you'll have a pending trademark once the application is filed, so you'll have some rights already.
Some level of protection. Yeah. I see. Yeah. So, what kind of fees? Let's say, can someone just do it by themselves, or do you think like they should have expertise, hire an expert to do it, and what kind of like they should expect like charges to be?
Yeah, for a trademark application, it's not something you can do yourself. I would say you should generally hire a lawyer. Most lawyers can't actually do trademark applications. You have to be a trademark agent. But yeah, there's a bunch of those in BC. We have them at our firm. A trademark, it's a fairly straightforward application. I think a rough ballpark, I think most lawyers charge $1,500 to $2,000, something like that for a trademark application.
For the whole application?
Yeah. Including fees and disbursement, stuff like that. Sometimes if there's like an opposition to it, like somebody challenges the trademarks and say, no, we were using it first or something like that, it can get more complicated, but most of the time that doesn't happen.
Yes, so that's for the normal case, a common case where you just want to file it, no competition, and including all the fees, government fees and everything, and lawyers' fees, whole application can be done $1,500 to $2,000.
That's a rough ballpark, yeah. I think what most lawyers charge, yeah. And you also, you don't have to do that when you first incorporate. I just want to emphasize that. You get trademark rights automatically just by using a name. Registering it is just recommended because it makes it easier to protect that trademark. And you should do it at some point, but it's not like the moment you incorporate, you have to do it or you'll lose your trademark.
I see. Okay. Yeah, so they don't have to rush into it, but they should think about doing it at least within a year or something after they have registered their company and started doing business under their name.
You should do it. It's kind of a risk and reward thing. Like if your name is unique and there's nobody else who's using that name and you don't anticipate any problems, you can probably push it off. If you think there's like a risk that somebody might be using a similar name, or you have like a name that you're considered may conflict with somebody else and you might have a fight over that, then you probably want to start that process earlier so you can at least deal with that to see if conflict exists when it happens.
So if you are like worried about the competition coming in or someone copying your idea or you try to copy your product, you want to trademark it sooner than later.
Yeah, especially if you're worried like there might be somebody else with a similar name out there. And you're worried about whether you're using a name that's similar to theirs. You might want to just apply for a trademark, see if they oppose it, or if they don't, later on down the line, if there's a dispute, you already have a registered trademark as well, so that helps your position as well. But you also, that's another thing you might want to do when you set up your company. Like a lot of people don't do this, when they look into choosing corporate name or their company's name or their business name that they're going to use. You might want to do some searching on the trademark registry. These are like free registries. You can look them up online and see if there's anybody using a similar name. And also just Googling. That's the best trademark search you can do because then the trademark doesn't have to be registered. The best way to find somebody with a similar name is just Google and see if they're using it. And double check if there is somebody using something similar, because you don't want to be in a situation where you picked a name, you spent 2-3 years building your brand, and then it's like, oh, wait, there's somebody else with a similar name, and now we have a dispute, but like we've been using this name, we can't change it, and it's a whole mess. So it's better to just know that going in and pick a name that's not going to be an issue.
I see. So have you seen any kind of like real stories, real life example where this happened and you had to like someone opposed the trademark and it took a long process of doing it?
I don't do trademark applications myself. We have another lawyer in our firm, or a couple of them, that do this kind of stuff. It's pretty rare to have an actual opposition for a trademark application, like when you file it. Like in theory, when you publish it, it gets published in the Canada Gazette, and people are supposed to review that and oppose it. More often, what will happen if there is some kind of dispute is they'll see your website and they'll send you a cease and desist letter, and then you have to respond to that, and then you have to have like an argument about who is using the name where, who has the trademark rights where, and hopefully you come to some kind of resolution, maybe saying, like, we'll use it in this area for these products, it's not a conflict, you use it in a separate area, or maybe you make some kind of change to your logo or trademark to sort of
But that's where
avoid
things
that
get
issue.
complicated.
Yeah, that's where things get complicated. It's better not to be in that situation.
Yeah, so moving on from the structure of the company, I do want to talk about or ask you what kind of early mistakes you have seen founders and a startup make that gets them into any kind of legal trouble.
So one common mistake I see, I don't know if it's fair to call it a mistake, but not adequately preparing for the startup not working out, or maybe one of the founders deciding that they don't want to be involved with a startup anymore and walking away from the project. And basically the issue is not having vesting in place for the founder's shares. So the way vesting works, I think most of your listeners know this, but it ensures that when you get shares in a company, you don't get all the shares up front. You have to stay with the company for a certain amount of years to get all your shares to include. So what happens if you don't have any vesting in place when you set up a company is, say you have 3 founders and they've been working on a project for 6 months, and 6 months in, one of them just leaves, says, I want to get a job, I can't do this anymore, I'm not going to be involved. By default, they still own 1/3 of a company at that point. And if the other 2 founders want to keep, advancing a project and keep working on the company, the third founder is still going to continue getting 1/3 of the benefit of that, even though we're not involved in the company, which can be a bit unfair and can result in disputes. So what vesting does is that if that founder leaves based on when they leave, they'd have to give a portion of their shares back. Like they'd keep some to account for the work they already did for the company, but they wouldn't keep, in that example, all 1/3 of the shares, because again, they're walking away and they're no longer involved. So having something in place like that from the beginning can be great to sort of address that issue when it happens. A lot of founders won't do that because it's kind of an awkward topic to bring up, and they think, we know each other, we're never going to have a dispute, and it's never going to happen. So they don't want to.
Yeah. I think the vesting is a very important thing to do. I think one of the thing what I have seen some very early, like first-time founders especially, they do when they get into like this startup high, when they want to start a company, register a company, what they do is they just registered it and have co-founders and everything. They don't even think about vesting. And when they look into vesting, they see that there's actual separate fees and costs attached to it to have a vesting contracts and everything done legally. So they end up not doing it, which costs them more in long run if the startup start generating some kind of revenue or raise money, and then a founder shareholders decides to, as you said, walk out. Then it's a lot more expensive to actually buy back their share and also do the legal litigation to make sure that you are not giving away 25% or 30% of your company.
Yeah, absolutely. That's, as with a lot of like legal things, sort of an ounce of prevention is worth a pound of cure. It's kind of what I like to say. Like, you getting this stuff dealt with at the start actually potentially saves you a lot of headaches and problems in the long run. And things go wrong, and you need this stuff in place, and you don't have it, essentially. And in terms of a cost, I will say that, like, not even me, but me and including most startup lawyers in town, they kind of understand that startups are like cash strapped to start, and they're not very they're like, look, we'll work with you, we'll wait until you get your shred claim in, we'll wait until you raise, that kind of stuff. So that shouldn't, if that's a hesitation for founders, I would say don't hesitate. Most lawyers will find a way to work with you. They know how the situation is. So just do it.
So another thing that I have seen early stage founders and partners and all, like founders make, is that they do not go for NDAs and all those confidentiality contract within themselves. Like it also finds them a awkward conversation to have, like, oh, you have to sign NDA and non-compete to enter into partnership.
Yeah, absolutely. So you have to make sure that you sign both an NDA and an IP assignment. So in theory, at law, if you're a consultant for a company, which most founders are, as you wouldn't be employees at a start because you're not paying yourselves. Any IP you create belongs to you, not the company, even if you're doing it working for the company. And if there's like a falling out and you haven't signed that NDA/IP document, then the departing founder can say, well, I actually own the IP, I actually own the code or whatever it is you created, not the company. And that, again, is a huge dispute. So that should be a standard thing that every company does at the start if you're incorporating. Get that NDA and IP assignment agreement in place, not only to keep company information confidential, but to make sure the company owns all the IP that you guys create and there's no problems with that moving forward. And that's a very simple, straightforward document. It's not something you have to like negotiate back and forth. Usually they're like 2 or 3 pages and they're kind of boilerplate. Even find one online and sign it, you're probably better off than not doing one at all.
Yeah, I think you have mentioned a very important point regarding IP, because I think not many people understand this, that if you're developing and working for the company as a startup, you need to have that IP and all the properties assigned to the startup, the company itself, not the individual. But if you're working on it and you do not have any kind of employment contract done and you are just working as a partner and a founder, you end up actually owning the IP when you create it. It's not the company. It's like a dispute in the end.
Yeah, absolutely. So you need that paperwork in place to get it done. Another issue that can come up is if you wait, say, like, a really long time, like a year or two, even if the founders are fine to sign over the documents to the company, if that IP is actually worth a lot of money when you assign it to the company, there can actually potentially be tax issues for the founders because on paper, at least, you're selling something that's worth a lot of money to the company, and there might be cap gains issues. I mean, there's ways around that. There's sort of Section 85 rollover. An accountant can help you with that, but it's still more paperwork and more costs that you can avoid if you just do that IP assignment to start.
I see. So other than this IP related issue, what other IP related issues you have seen come up?
Another issue that comes up a lot of the time is getting these assignment agreements, not only from the founders, but from other people the company works with. So if a company hires a consultant, for example, video game studios, a lot of the time they'll hire people to do art for them or music or sound or stuff like that. And like it's kind of a one-off engagement, like they'll work for a few hours for a few $100, something like that, to create those IP assets. You have to make sure you get something in writing from them as well as signing that IP to the company, because otherwise, again, if they don't sign that, then in theory, the company doesn't own the IP they created. And if you integrate that into your product and use it, and you don't have the right to it, you can have problems later on. And a lot of the time, it doesn't really come up. Like the person who created that art for you they're not going to sue you, and you're not going to cause a problem. But say you want to sell the company or you want to take an investment later on, the investors, as part of their due diligence of a company, are going to want to see, okay, do you have IP assignments of everybody who did work on all this stuff? Can you show like a clean chain of like IP ownership? And if you can't, then it's like, oh crap, I have to go back and find this person and get him to sign something now, or otherwise we can't close the deal. That does happen sometimes, where like sometimes in the 11th hour, like the companies realize, oh, we don't have all these IP assignments for all these people that work for us, and you have to go and find them and get them, otherwise you can't close the deal.
Yeah, so when investors comes in and if a company is being acquired, they're going to look all of it. They're going to go through the extensive due diligence to make sure everything is in place, and that can impact how your investments are going to work. That's going to impact how your acquisition is going to work. And if, let's say, as you said, you have to go back and then get it signed, and that person refused to sign or ask for some kind of incentive to sign it, then that's something that to look out for as well.
Yeah, absolutely. That's why it's better just get all this stuff signed when it happens, when you work with that person with waiting. Again, prevention is better than cure. To get to that point, it's going to be way more complicated.
So I do want to ask, like, let's say if we create a basic list of essential contracts, founders should familiarize themselves with before they initiate the company. What kind of contracts and legal aspect of things they should be like making a list of?
Yeah, so the basic stuff that we kind of see with every company when you set it up is, first of all, the paperwork for the incorporation, like they're called the articles of incorporation for the company. What are the kind of the rules of like when you need to have shareholder meetings, who's on the board, all that kind of stuff, or how the board process decisions work. That's basically boilerplate. It's kind of the same for every company. You might change the share structure a little bit, like the types and classes of shares, but yeah, it's pretty straightforward. Another document is generally a shareholder agreement or a similar agreement between the founders that kind of governs how the company is going to work, like who the directors are going to be. Generally, that'll be all the founders. If there's any kind of a sale of a company, what happens? Generally, it'll say that everybody has to approve it and participate in the same way. Again, there's a lot of legalese that goes into this, but that's basically the long and short of most sections. And most of the time, you'll need a reverse vesting agreement or some kind of vesting agreement with all the founders. We already discussed that and why you need that in place. Usually, if there's a falling out between the founders, it kind of gets resolved for the vesting. And if you don't have it, it's a bit more problematic. And finally, just those consulting agreements between the founders of a company that will have confidentiality language, IP assignment language, all that stuff, just to make sure they're up to it. So basically 4 things: the incorporation, the shareholder agreement / founder agreement. There's different ways to do it, but the shareholder agreement is the most common. The vesting documents and the consulting. That's kind of a basic standard stuff that every company needs. And then it depends a little bit later on kind of what business you're in, who your clients are. Usually you'll have like either terms of service for your website if you're B2C, privacy policy, some kind of master service agreement if you're B2B. It depends. If you're in like a regulated industry, you might need some kind of license or registration. It varies. But those 4 documents kind of a core starting documents for any startup.
I do want to move a little bit forward in terms of the startup journey. So let's say a company, they did all that. Now they are in a phase of hiring their first employee. So what kind of thing, like an employment contract, what they should include? I know that basic thing to include is, first of all, non-compete and NDA and non-disclosure agreement. But how long that non-compete can last? How many years of non-compete that is viable or allowed in Canada? Is there any limit to it?
Yeah, there are rules in Canada. The courts are kind of very hesitant to enforce non-competes in Canada because you're basically preventing somebody from working. So they'll only enforce it if it's kind of limited in scope based on how long the non-compete lasts and the geographical area it applies to. So generally anything above like a year, the courts, 1 or 2 years, the courts probably won't enforce. And the geographical area, again, if it's very wide, if it's like all of Canada and North America or something like that, the courts
It
probably
won't be
won't enforce it.
enforceable.
And most of the time you don't need that. You only want like a Greater Vancouver or something somewhere.
I see.
But I would say that non-competes I would not necessarily insist on those. That's kind of a case-by-case thing. If you're in a very specific industry and you're concerned if your employees competing, you might want to push for that. But there are situations where like a company can say like, we're not going to have a non-compete. It's fine. It's not 100% standard.
But NDA should be there.
Yeah, there is other stuff in that agreement that is very standard. So non-solicits, like you can't go after company clients or you can't try to hire away the company's employees if you leave. That's standard. IP assignment, obviously, like the agreement will say that they assign all the IP to the company and all that stuff. Confidentiality, you can't use any company information. All that is kind of standard. and boilerplate in these agreements, and you need to have that in because if you don't, and the person leaves, you can have problems. There is one other thing I wanted to bring up that people kind of don't know about in regard to hiring somebody. So there's actually two ways somebody can work for you, as a consultant or as an employee. And it's very important to be aware of the differences between those two. Generally, you actually want them to work for you as a consultant because it's a lot simpler. There's less overhead. If you're a consultant, you don't have to remit taxes to the government. You don't have to pay CPP, EI remittances. You don't have to worry about severance if they go. You don't have to worry about, the Employment Standards Act and all that stuff. It's a lot simpler to have somebody work for you as a consultant instead of an employee.
So as a consultant, that person will be reporting their own taxes and paying those taxes. You are just paying straightforward the fees you decided on in the contract.
Yeah, so you don't have to hire a bookkeeper and do the remittance every month and give them a pay stub. They can just give you an invoice and you can e-transfer them. It's a lot simpler. A consultant is basically, the way somebody does a job for you. If somebody comes and, paints your house or something, they're doing a job for you, they're working for you, but they're not an employee. They're kind of an independent business doing work for you. That's what a consultant is. They're not an employee, they're an independent business person working for you. And because of that, you don't do remittances, you don't treat them as an employee, and it's a lot easier for the company. So generally, most companies will want to hire somebody as a consultant. If you're a founders, you'll be on as consultants because you're not employees, because if you were, you'd have to pay yourselves at least minimum wage, for example, and you don't want to do that. You don't want to remit taxes and all that. But if you are a consultant, you can't just call somebody a consultant and then they're a consultant. It kind of depends on the relationship. If they're working for you 40 hours a week from your offices, under your direction, using your equipment, that kind of stuff, then they're probably an employee, and you should hire them as an employee and do the remittances and all that stuff, and hire a bookkeeper and deal with that overhead. But there are situations where they're working for you part-time or a more limited situation where you might want to look at hiring them as a consultant. So it's something to be aware of. Look into it when you're hiring your first employee. Be aware of it, look into it then, but just want to flag that for people because a lot of people aren't really kind of aware of it. They just think, I'm hiring somebody for an employee and that's it, but it's not quite this.
Yeah, so there's a fine line between consultant and employee as well. You can't just call someone a consultant, but they are working in your office with your equipment and coming in every day, working 40 hours a week.
Yeah, so if you do that, if you call them a consultant and they're actually an employee, and then say you get audited by the CRA or they apply for EI after they leave, because you can only get an EI if you're an employee, and somebody comes in and looks into it and determines that, even though you call them a consultant, they're actually an employee, you can be liable for the tax you failed to remit. Penalties on top of that can be a huge problem. So you want to be a little bit careful. Yeah, you want to be careful about this stuff, especially if you're hiring somebody full-time. There it might be safer to hire them as an employee, but just be aware of your options.
Thank you for sharing that. So now moving into another phase of a startup when they are taking in investors and raising money. So now what kind of thing they should look out for when they are raising money? I have seen a couple of startups, not going to name anyone here, but when they were raising money and they were going into investments, taking in money, they ended up raising in a way that ended up giving the investor more rights over the company. So that was something that I feel like they should know how to do.
Yeah, so you want to be aware, first of all, the most important thing is what sort of instrument you use to raise money, like what kind of legal paperwork. So there's different options. There's, raising straight equity where you actually sell somebody shares in your company at usually a fixed valuation. And that gets pretty complicated. Usually there's a whole term sheet. There's all these rights that the investors are going to insist on. They're going to become party to your shareholder agreement, or more likely they're going to ask you to replace those documents with something that sort of they came up with. That sort of gives them some protection. They might ask for a board seat, rights to follow on future investments, how their shares get treated if there's a sale. It gets pretty complicated. And that should not be, if you're an early stage company raising a seed round, that should not be your first option ideal, unless you're raising 2 or 3 million in a significant amount of money. If you're a startup and you're just getting off the ground and doing kind of like a friends and family round, raising 20 grand from this person, 50 grand from this person, kind of stuff, you're much better off using a SAFE. Stands for Simple Agreement for Future Equity. They were invented by Y Combinator a few years ago, and they're very popular. They're great because they're very, very simple. There's basically no negotiation to a SAFE. You just give it to investor. There's two things you kind of based in there is the valuation cap, like what's the maximum valuation that the SAFE's going to convert at, and the discount. And I can explain these a bit more after the SAFE works, but I tell you how the SAFE works. But it's a very straightforward document. There's no negotiation. There's no back and forth. You don't have to agree on a valuation for the company. Mm-hmm. The investor just agrees how much we're investing. And the way a SAFE works is basically the investor, puts this amount of money in the company, and it's not a specific valuation. They don't know how many shares they're going to get. The SAFE just says that if the company does a priced round later on, like the kind of round I mentioned, where you're raising 2-3 million, and there's a term sheet and all that kind of stuff, and there's a firm valuation for the company where shares are issued, then the investor gets shares as well based on the amount of money they put in, usually like at a discount, because they put the money in earlier, so they should get a few more shares. So like your shares are valued at $1 a share when you do your press round, they'll get their shares potentially at 80 cents a share, so they'll get a few more shares. So if they invested $50,000, they get $50,000 divided by 80 cents. That's how many shares they're getting.
So with SAFE, sorry to interrupt you. Just wanted to confirm. So with SAFE, they are not actually releasing any kind of shares initially when they take the money from the angel round or friends and family round.
No, a SAFE is just an agreement to issue shares in the future when you do a priced equity round. So
it can say which round. Basically, it can say it might be seed round or Series A round. That's when they're going to release the share.
Yeah, usually it'll say if you're raising at least X amount of money, usually it would be the first priced round you do that the SAFE converts that. Unless you're raising like a very small amount, then maybe it doesn't hit that qualification. Most of the time, you will convert. And the great thing about the SAFE is you don't have to agree what your company is worth. You don't have to agree on all those shareholder rights, any of that stuff. That gets pushed down later on when you do the price round, which is why it's a lot more efficient for companies. It's a lot less legal paperwork, a lot less expenses. They just sign the SAFE, then you have money invested.
And you're also like further along and you have proven your idea, market validation, and that actually improves your company valuation as well, comparison to if you end up giving up equity in friends and family or angel round. You might, if you are doing simple equity, you might end up giving a lot more because they will ask for market validation, which you don't have at this point.
Yeah, doing a priced round, like when you're very early stage and you don't have like a product yet and you don't have revenue, it's very tough. It's a crapshoot to evaluate a startup at that point. So a lot of the time, it's better not to have that whole conversation about what's this idea worth and all that stuff. It gives you time to sort of build on the idea. You have a little bit of investment capital, and then once you do a priced round, that applies to the SAFE investor as well. Like that gets negotiated later on, and the investor gets the benefit of that discount in the SAFE or the valuation cap, which will say say your company does really well and like it's worth $100 million when you raise or something like that. The valuation cap will say that, there's a $10 million valuation cap for the investor. Their shares convert, assuming the company is worth 10 million, not 100 million. So they get a lot more shares, again, because they invested earlier. A lot of people look at the valuation cap as kind of like the informative valuation for a company in a SAFE, but people should be aware that that's not what it is. It doesn't mean your company's worth $5 million when you do the SAFE. It's kind of like there to protect an investor. It says that no matter what, they'll get shares, assuming your company's worth $5 million or less, no more than that, even if you raise it at a higher valuation.
No, that's, I think that's very important to do. I was not also very sure about SAFE when I started in the beginning, but we didn't even do the seed round at that point. So it's So it was okay for us.
Yeah, worth
Yeah.
it.
So other than safe, what other methods they can use to protect themselves from taking a lot of money?
I mean, one other issue is sort of deciding whether you're going to raise and who you're going to raise from. Uh, so there's kind of a lot of talk right now about whether venture capital is right for all companies. For most companies, most startups, it's actually not like it. VCs, you know, they want to take a company and grow it, 10x, 100x, scale up like crazy, and
Yeah.
that's how they make their money, and that's their business model. But for a lot of companies, that doesn't make sense. For a lot of companies, you don't really need that, and it's going to be kind of a bad situation for both you and the investor if like you want to do one thing with the company and they want to do a different thing. So one thing for a lot of companies to consider, everybody wants to say like, we talked to all these VCs, we raised X million dollars. But again, that money comes with a lot of strings and a lot of pressure. It's a lot more, getting that term sheet. There's a lot of like legal stuff you have to worry about all the rights and terms and all that stuff. For a lot of companies, you might be better off raising from angels, a more limited amount, or even if you're not doing safe, you can do an equity round of angels too, but it's usually a lot less complicated than with a VC because you're not going to have this full term sheet with complicated terms. So for a lot of companies, I would say the legal documents can protect you to a point, but the best thing you can do is kind of decide how much you want to raise and who to raise it from. And that doesn't always mean raise the most money you can. Because if you're at an early stage, that's when your company is going to have the lowest valuation. That's when you're going to get to give the most of your company up to investors. And if you need that money to scale up and to grow your business, that's fine. But if you don't really need that money, you only need if you don't need $1 million, you only need 300,000 to sort of build up this MVP and this works, to see if it works and put it out there and see if you can get some traction. You're much better off just raising 300,000, building the MVP, seeing if it works, and then if it does, you can raise the other 700,000 at like a wide better valuation and get way better terms than trying to raise a full $1 million, which may be a lot harder to do. You might get in bed with an investor that has different priorities from you, and it might not be as good a situation. So I would say, choose how much you want to invest, how much you want to raise, and make sure it fits your plans and your situation, and only raise kind of what you need.
In any of those situations, can like raising a lot of money and running a business, can founder become personally liable at any point?
No, generally not as long as you incorporate. So a corporation is, as most people know, is a separate legal entity from its founders. So that means if a corporation gets sued or if things goes bankrupt, something goes wrong, your creditors can only come after a corporation's assets. So your company will go bankrupt, it'll be done, and that's it. But they can't come after your personal bank account, your home, and all that stuff. So it is very important when you are a founder to incorporate before you sort of start doing business and kind of go out into the world and start signing contracts, taking loans or taking investment, all that kind of stuff. You need to be incorporated to protect your own personal assets. And sometimes, like if you're taking a bank loan, a bank might ask for a personal guarantee. Yeah. There are exceptions to that kind of stuff, but generally,
that's why I actually asked, because one of the things recently I read about was that banks sometimes do put in clause that require you to become personally liable to a level. If you go bankrupt, you have to pay it back by selling your personal assets. So I wanted to get some clarification on that.
So yes, banks will do that sometimes. I mean, banks, they're not VCs. They're in the business of lending for a small interest rate, and they're not like, we're going to lend to 10 companies, and if one of them hits, we're going to make a lot of money. They want their money back plus interest. So bank funding, I would say it's probably not going to be a very good option for most startups because it will be a loan and you'll have to pay that money back, and they will ask for personal guarantees. So you are risking your personal assets at that point. So there's other options there. There's like non-dilutive funding. There's government grants. shred credits. Obviously, you have to be spending money at that point on R&D and stuff like that. But there are other ways to raise money that don't involve bank loans. Some banks now will lend against revenue. If you have ongoing revenue, you can give a piece of that. There's a lot of sort of entities that have sort of unusual funding structures that can work. For most of those, you generally have to have an operating business and be bringing some revenue. But if you're a startup and just getting off the ground, I mean, it'll be hard to get a bank loan either way, I think, because they might deem it risky for a large amount of money. But I would say try to go to investors first. And with an investor, you should absolutely not be personally liable. They're investing in the company. The company doesn't succeed, then that's it. They lose the money, and that's it. They should not be asking for any kind of personal guarantees.
I would
Any
be very
investor asks for
careful
that, yeah, run and don't deal with that.
Yeah. So since we're talking about liability, I do want to ask a few more questions. But for this, to make it a bit more specific, because I'm sure that there's like a lot of way a person can become liable and business can become liable. But let's say we are in a consumer retail business, we're producing a product and selling it. Can consumer in some way sue you and your company becomes liable because of the product that you put out?
Yeah, they can. It depends on what your product is. I mean, yeah, people can always sue you. There's nothing you can do legally to prevent somebody from suing you for anything. It doesn't mean they'll win, but they can sue. If you're talking about liability to consumers, like if you put a faulty product out there, you might deal with individual customer complaints. Those are kind of, you deal with them, your customer service team can deal with it on a case-by-case basis. You'll want to have like a terms of service on your site or included in the product, some kind of shrink wrap agreement, something like that. That kind of talks about here are your rights, you can't sue us, all that stuff. What you should be more, I don't know if it's fair to say should be, but like what a bigger concern will be, like if there's some real fault of your product, you might be looking like at a class action where you don't see those that often. It's, again, I don't do class action law, I'm not an expert. It's not something I would be that concerned about unless your product is sort of like inherently dangerous or something like that. But for most products, for somebody to sue you, they'd have to have suffered some form of damage, like the product needs to have hurt them or something needs to have happened. And if you're an app and the customer can't show that level of damage, you can't show that level of damage affects every customer, it's going to be tough to deal with that. So it's not something I see for most startups. Like it's not on the list of like 100 things I should be worried about when I'm starting a company. Getting sued by your customers, unless you're doing something very unusual or am sort of expose them to some kind of risk, it's not that big an issue as long as you make sure your product is sort of effective and works. If there's been a lot of class actions or data breaches recently, for example, like if you lose customers' data or something like that, then yeah, you can be in a lot of trouble. So you would be careful of that. You want to make sure, especially if you're taking credit card data, you might want to use something like Stripe or something like that, where you're not actually in possession of customers' financial information. And there's actually a lot of regulatory stuff that comes along with that. So most startups, it doesn't make sense to do that. So you might want to look at a third-party provider for that kind of stuff, just to be careful about the data you're collecting. And you want to make sure that you have some stuff in your terms of service that says, you can't sue us. Usually it'll say like you can't sue us in a class action. You have to take us to arbitration if you want to sue us, all that kind of stuff. It's good to have that stuff in. The courts don't always enforce that kind of stuff. It's actually like a dispute now, the case on when these arbitration clauses are enforceable, but it can give you some protection. So it's something.
Yeah. So, and this is for startups that are a bit far along in their journey.
Yeah, I mean, this is if you have like a bunch of customers and you actually bring in revenue, which is a good problem to have for most startups.
In terms of cost for these kind of things, that I think the legal cost kind of builds up quite a lot. I believe there are insurance companies as well that gives you protection in case you get sued, in case your company comes under fire, they are able to come in?
Yeah, there's types of insurance you can get as a company or as a startup. So one of them is commercial general liability insurance, it's called. That basically means if you work with a customer and you make a mistake and the customer sues you, the policy will cover you. And a lot of the time, if you're working in a B2B business, your contracts with your clients will actually require you to have that policy in place. Like they'll ask you to get that kind of liability insurance to work with them. And the reason for that is, say something does go wrong and like there's like a $3 million claim, your startup might not have $3 million to pay the client, even if you are at fault. So they'll want you to have insurance so that the insurance company can cover that liability. So for most startups, I'd say that's when you start dealing with insurance first, is when you have a client and they ask you to get insurance. And then there's insurance brokers you can talk to that deal with this stuff, and they can help you with that kind of stuff. There's also errors and omissions coverage, which is similar. There's also a director and officer insurance, which is if you, as the directors and officers of a startup, you have certain obligations to shareholders and the company. And if you get sued, you can get insurance that protects you if you get sued as a director. And a lot of the time, the company will get insurance for you in case you get sued. But with startups, that's not, most of the time as a startup, you're the only shareholder to start, so you're not going to sue yourself. Even if you have an investor, you have like 2 or 3 investors, so that's not something you usually see. You usually see that later on if the company goes public or you have a lot of investors. So it's not something you see most startups.
Yeah, so you have to start thinking about these kinds of things when you have put out your product and your customers are interacting with it.
Yeah, you do.
Right. So these are actually the most of the questions that I received, and I tried to add few of my questions as well in there. But thank you so much for answering all these. But before we actually end it, I do want to ask if you have any kind of advice for new founders or first-time founders.
Yeah, in general, so I would say, first of all, get all your legal ducks in a row to start. Most of the time, you're going to be thankful you did, or it's going to be more of a problem later on if you didn't. That's general advice. Another thing, you already talked about reverse vesting and all that stuff, and that be careful about that as well. That's one problem I see a lot. Aside from that, one thing I see a lot with startups is you want to make sure that you look at all the sort of the regulatory landscape and the issues you're going to have to deal with with your company moving forward. So do some research, first of all, like if you're in a regulated industry like crypto or anything financial, there's a lot of regulation in these industries. I had a client like last month who I was talking to who they started a company, they're very excited, and they have this financial / crypto product. But it turns out they may have to register as a securities dealer or potentially as an exchange, and there's all these other registrations, and these can be lengthy processes and like a whole pain to deal with. And a lot of the time people kind of start the company, get excited without looking into the stuff, and then these clients, for example, are like, oh wow, there's a lot of stuff we have to like deal with, and we're gonna have to raise to basically make sure we cover all this stuff. So make sure you have a good idea of like what the landscape is for your industry, and like plan out any kind of licenses you need, any kind of regulations you're going to have to deal with ahead of time, so you're not surprised later on. And even stuff like make sure your name, a lot of people don't think like, what if somebody else is using a name similar to mine later on, and you don't want to put a few years into building a brand and find out how somebody else is using with similar one you have a dispute. We already talked about that kind of stuff. So a little planning about this stuff generally can go a long way.
Yeah, so plan ahead before you start initiating these kind of things.
Plan ahead. Look at the regulatory kind of landscape for your industry and figure out exactly what you're going to need to do, because a lot of the time that can be a lot more work and a lot more problematic than you thought. So it's best to know that going in, then figure out like after you put 6 months work into something like this. You're going to need all that stuff.
Yeah. And when you're starting with the partnership, make sure you have a vesting contract in place. You have NDAs in place so that if a partner leaves, your equity of the company is protected, your IP is protected, and you are not getting into trouble.
Yeah, absolutely. I mean, founder relationships are like a marriage. That sort of metaphor gets used all the time, but it actually is. And going into a marriage, nobody expects we're going to get divorced. And going into a startup, everybody thinks, everything is going to be fine and we're not going to fight and everything's going to work out well. I can tell you from experience, it doesn't always happen. Things break down. Even though it's awkward at the start, it's best to sort of plan for that ahead of time than have that happen and not have a plan in place.
So vesting contract is So vesting contract is basically prenup.
Yeah, prenup, vesting contract of a shareholder agreement. Yeah, it's best to have a prenup in place than spend money on divorce lawyers later on.
Okay. So thank you so much, Marius, for coming in and sharing all your advice and answering so many legal questions that the new founders and startup CEOs face. Just want to reiterate a lot of things that you said about contracts in place, and we have already talked about vesting contracts, IP protections, and NDAs and non-compete, which doesn't really apply sometimes, but still, if someone wants to put it in place, they can. And also, just want to thank you in general for sharing all the advices. And your office is located in downtown, I believe.
Yep, I'm downtown. You can also, just Google my name. I'm sure you'll find my LinkedIn, my Twitter, all that kind of stuff. If anybody watching this has any questions about the legal stuff, feel free to reach out. I'm always happy to chat. Yeah.
I'll definitely link all your socials and as well as your company website links so that people can easily find Segev. And if they have any more questions, they can reach out to you. Are you okay with reaching out to LinkedIn or email?
Whatever people prefer. I check all that.
Okay, I'll just link both of it. Make sure they get the most convenient way for them to reach out to you. Once again, thank you so much, Marius, for coming in.
No problem. Happy to. Have a good one.